Hello, I'm Andy Agathangelo. I'm very proud to be the founder of campaign organisation Transparency Task Force. We are a UK-based but very international certified social enterprise, and our purpose is to promote reform of the financial industry so it serves society better. We want the financial industry to be more transparent, more truthful, more trustworthy. We do believe that the financial sector is profoundly important to the well-being of society, to economic stability, and also to political stability. But we also believe the financial industry has a high predisposition to misbehave. And of course, that misbehavior can sometimes be relatively trivial. Sometimes it can be very, very serious. For example, people having their homes unlawfully repossessed, or people running businesses who find themselves having bought toxic, highly risky interest rate hedging products that they never really wanted or needed, that turned out to become complete nightmares for them and their finances. Um, when things go really, really badly, it can even lead to people harming themselves or even worse, taking their own lives. We are talking about some really serious issues here. One characteristic of the battles that people have when they are fighting the regulator or a financial institution, let's say a bank or a big insurance company or a big investment firm or whatever it might be, one of the characteristics is that it is typically a David versus Goliath battle where the other side has got lots of money because it's, for example, a bank, lots of lawyers, lots of experience, lots of expertise, frankly, lots of everything. And the individual fighting the battle often has nothing and sometimes nobody to support them. So it's really very frequently a tremendously unfair battle. It can be heartbreaking to understand the battle, and it can cause a great deal of harm. And because folks are often terribly under-resourced, they sometimes find themselves going to court representing themselves. And that makes the David versus Goliath battle even worse because they are having to learn the legal profession in some ways whilst trying to prosecute a case against the other side. And they know that they don't really know what they're doing, and they're sometimes clutching at straws, and it can be really quite devastating and demoralizing, especially if you lose. And unfortunately, the harsh reality is people often do lose. People often would lose, even if they did have a lawyer acting for them, even if they did have a barrister, or even a team of barristers or a team of lawyers. Why? Because the other side is typically a bank or some other institution who sometimes do make the strategic decision to win the case at all costs and will just throw as much resource at it as they need to grind the other side down. I'm quite deliberately kicking this conversation off in a bleak tone because believe me, I do understand and can relate to what it's like. On Friday last week, for example, I was in a magistrate's court with one of our members who was having a David versus Goliath battle. The other side had a very, very well informed and remarkably competent barrister who knew all the ins and all the outs, how to dot the I's, how to cross the T's, all the case laws, even the relevant page numbers in this massive, great big bundle that was in the courtroom. And frankly, when this barrister finished speaking, I would have given our guy 10 to 1 chance of doing well at that hearing. To my absolute delight, the individual concerned fought back in a compelling and clear way. He'd spent so much time and effort learning about his case that he really did do himself and his case justice against a great big opponent with a lot of resource, with a strategic imperative to win the case. I don't know what the outcome of that case is going to be. It'll be some time before we know what the judge decides. But I do know that that person handled himself brilliantly in that courtroom on that day. And any of us would have been proud to witness what I was proud to witness. An individual who knows he'd been wronged, fighting back and giving it everything he's got. And whether he subsequently wins, inverted commas, or loses, inverted commas, that individual will be able to look back at what he did that day with a sense of pride and a sense of satisfaction that he fought back as best as he possibly could. Some time ago, some of us were chatting about the challenge that litigants in person have when they're in a courtroom on their own without legal support. And we had the very simple, straightforward idea. Maybe there are thoughts we can share amongst ourselves to help those who are having to fight the case on their own because they don't have the money to do it any other way. And that's what led to the conversations we had, that led to the conversations between myself and John, who you're going to be hearing from, that led to us putting on this event. So think of tonight's session between now and about 7:30 UK time. Think of it as a self-help group, learning from each other, sharing ideas, insights, expertise, doing what we can to help each other because we all deserve the support we can try to get. And if we can provide people with ideas that they can in some way implement, then that'll be really worthwhile. I've got a very, very, very strong sense of purpose about this event. I'm thinking we'll probably run it every 3, 4, 5, or 6 months. We'll make it a regular thing and we'll continue to build on our knowledge and we'll continue to build on our experience and our expertise and get better at sharing intelligence, get better at sharing best strategies and tactics, and get better at, for example, harnessing the truly incredible power of AI. Knowledge is power, they say. I don't think that's quite right. I'd slightly refine the statement. Knowledge is power if effectively applied. And tonight's all about that. In a moment, we're going to be hearing from John, then Steve, then Magella, then Paul Bates. Can we, first of all, show our appreciation to John Barwell, who is very much the backbone of tonight's conversation? And for reasons that will become very, very clear, I feel very, very, very fortunate that we have with us tonight. John's going to introduce himself, tell you a bit about how he got into this space, tell you a bit about Legal Lens, his organization, what he does, why he does it, and then he's going to work his way through some slides and hopefully bring everybody up to speed a little bit with awareness. We'll take questions and comments kind of between the speakers, so let John get through his stuff first and then we'll open up to questions and comments. We are recording the session. Of course, there were lots of people who wanted to be here tonight who couldn't be, but we will be sharing the recording and we'll also be sharing the notes that you put into the chat. Use the chat to make comments, ask questions, so on and so forth. But first of all, folks, can I please invite you to show our appreciation, first of all, to John, our key speaker, before he takes the microphone. John, over to you. Thank you very much indeed. Well done. And thank you for being here, John. Please take time to introduce yourself, set the scene, and cover the ground that you want to. Thank you, John. Thank you.
Thank you, Andy, for the introduction. Just to echo what Andy's talked about, I agree totally with everything that Andy said. My journey began quite a few years ago, and it was a bit of a strange one for me because I never thought I would end up down this road, but I was forced down this road. So I'll try and make a long story short, so you know where I'm basically coming from. I had a solicitor which drafted my will, and in my will were my business assets for my children. And one of the business assets was a toy company that I used to run, which unfortunately I don't run anymore. And I had premises, and we had a bit of a dispute between the rent, and there was some arrears, and the landlord also owed me money as well. Um, and what happened a couple of years ago, I was awakened because I'm from an IT background. All my alarms were going off in my office and in my warehouse. Wasn't sure what was happening. The warehouse was literally maybe 5, 10 minutes away from my home. I drove down, and when I got there, there was a sign on my door, and basically the bailiffs went in and changed the locks. Um, and the notice on the door said to contact a solicitor firm called Burnett's. Ironically, Burnett's also drafted my will. Um, so I contacted Burnett's. They basically told me um, they've took possession of the property due to arrears. And that's when the whole saga began for me. And it was a steep learning curve because our stories will be different, but the themes will be very similar with respect to how we think the actual justice system works in the UK, and how it does actually work is two different stories. So I was pretty confident that I was in a strong position, but our justice system isn't the greatest. And when you go to the regulators expecting them to step in, they don't really step in, they step aside. And you're faced with an uphill battle against basically, let's call it what it is, criminals, because that's what they are. Most of the solicitors that I've come across anyway. So that's a little bit about my story. I've got a slideshow. It's only very short, 10-15 minute slideshow. I pre-recorded it today, so I would like to share that with you. And I think this discussion will be better once we open it up to questions. So I'm just going to share the presentation that I've done this afternoon with everyone. Like I say, it's only 10 minutes. It's pre-recorded. And once it's finished, we can open up the floor to some questions.
Good evening, I'm John Barwell, founder of Legal Lens. We focus on how litigants in person, LIPs, interact with courts and tribunals, identifying procedural pressure, resource gaps, and hidden norms. We also build tools, templates, and guides to help LIPs operate with strategic discipline. In today's session, I'll map the LIP landscape in civil, employment, and family settings, unpack common procedural traps, and try to equip you with strategic countermeasures you can apply. Here's where we begin. In employment tribunals, the representation gap remains stark. From the CETA 2018 survey, 77% of employers, but only 41% of claimants were represented at final hearing. More critically, in January to March 2025, 77% of ET cases did not progress to a hearing, a powerful indicator of attrition. In October to December 2024, ACI data shows 79% did not progress. Under the new rules, the backlog and open caseloads remain heavy, implying that many claims stall before substantive adjudication. In family private law, official published statistics rarely report a simple lip rate. It is well accepted anecdotally and in court user studies that many parties appear unrepresented, especially in lower complexity or emotionally charged disputes. In civil courts, lips are more common in small claims or fast-track cases. Multi-track and high-value work tends toward representation. The through-line inequality of arms in time, information, procedural fluency is systemic, not occasional. 3 recurring procedural traps. 1. Bundle mismanagement. Unnumbered pages, inconsistent pagination, multiple versions, missing indices. A judge who loses confidence in your bundle often sidelines your case even before hearing. 2. Cost threats and unreasonable conduct in civil courts. Cost shifting is foundational. In employment tribunals, although cost awards are exceptional, behavior described as vexatious, abusive, or unreasonable can trigger costs. Respondents routinely use cost threats as leverage. 3. Disclosure overload or delay. Opposing counsel may demand sweeping disclosure or roll out late document dumps. Lips either over-disclose or miss deadlines. Either choice becomes a procedural weakness to exploit. If your case trips on these, your opponent may shift focus from merits to the mechanics. Your first defense must be procedural discipline. Let's set disciplined counter strategy. Frame early. Draft a list of issues that ties each allegation to a cause of action and to the minimal evidence required. This becomes your anchor for directions and your defense against drift. Timeline discipline. Keep a live dates ledger for all deadlines, orders, hearings. After every hearing, confirm directions in writing and ask for a formal case management order if ambiguity persists. Fight with the rules. Under ET Rules 2024, Rule 3 is the overriding objective, now elevated in language. Strikeout is Rule 38, unless orders are Rule 39. Deposit orders under Rule 40. Tribunal must provide reasons and notify consequences. On deposit orders, commentary and your own guide accept a ceiling of £1,000 per specific allegation or argument with a means inquiry and room for nominal/staged deposits if hardship exists. In civil, rely on CPR 1.1, overriding objective, CPR 3.1, case management on represented parties, CPR 3.4, strikeout, CPR 24, summary judgment, and CPR 32/PD 32, witness evidence. Every application or response you file, cite the rules, argue proportionality, and close with, I respectfully invite the tribunal/court to order X under Rule CPR, and then give a brief justification. If faced with strikeout/deposit, propose lesser, narrowed alternatives and support them with means evidence if requested. That shifts burden back to the tribunal/respondent to justify aggressive lines rather than giving them a monopoly on procedure. Your evidence is your narrative in formulaic form. Do this. Organize witness statements by issue headings. Number paragraphs. Each assertion must cross-refer to an exhibit or explain its absence. Use a single unified chronology and consolidated bundle version. Avoid evolving, conflicting versions. If a document hurts your case, include it and explain it. That builds credibility. Omission is worse. Resist overloading. Judges scan for relevance, not volume. A curated, narratively coherent bundle is more persuasive than a mass of marginal documents. In submissions, map facts to law, highlight key documents, and show how your evidence satisfies each element. Precision and narrative coherence elevate your position above noise. Before we move into bias and escalation, I just want to take a moment to talk about a prototype we're developing using AI and retrieval augmented generation for litigants in person. It's not yet live, but this is the functionality we're designing. You'll first select the area of law, employment tribunal, civil court or family court, and your current stage, such as post-conciliation, pre-hearing or on appeal. The system will then analyze your uploaded materials and return a complexity grade, red, amber, or green, indicating how procedurally demanding your case appears. It will also flag procedural risk areas, for example, deposit order exposure, weak pleadings, strikeout vulnerability, or missing evidence links. Based on that assessment, it will generate next step templates, draft wording for a case management order proposal, a phased disclosure request, or a deposit order response complete with means evidence section and suggested authorities. Behind the scenes, it will maintain your dates ledger, create a bundle/issue evidence matrix, and run completeness checks so you can see which procedural steps or exhibits remain outstanding. We're testing it internally now, aiming for integration with reliable open law sources, legislation.gov.uk, judiciary.uk, and a CAS guidance, so that any output you get is traceable and legally grounded, not guesswork. Until it launches, you can still use the free resources already published. The Equal Treatment Benchbook for Accessibility and Participation Issues, a CAS, Early Conciliation Guidance, the HMCTS and JCIO websites for procedural and conduct complaints. For low-cost tools, PDF indexes, Bates stamping utilities, and voice-to-text dictation save huge amounts of time in preparing statements and bundles. Bias must be framed in legal doctrine, not impression. Use Porter v. McGill case law. The question is whether a fair-minded and informed observer would see a real possibility of bias. When to act. Watch for differential treatment, procedural anomalies, prejudicial comments, conflicts not addressed. Frame your recusal application narrowly. Point towards timing, effect on fairness, and what remedy you seek. Routes. Case management decisions, pleadings, directions, usually challengeable by appeal, not via misconduct route. Judicial misconduct or arbitrary conduct. Lodging a complaint with JCIO within 3 months is the correct path. JCO reviews how JCIO handled your complaint. If you believe the complaint handling was flawed, don't conflate these paths. Your primary defense remains pleading discipline and early challenge, not hoping for judicial rescue. Recent decisions like Mervyn and Mustache confirm limits on tribunal reconstruction, so do not rely on judicial beneficence to shore up missing or weak claims. Here are 10 tactical actions you can implement immediately. 1. Diarise all deadlines, pleadings, service, disclosure, directions. 2. After each hearing, confirm directions in writing and request a formal CMO if any ambiguity. 3. Maintain a master chronology, updated and included in each bundle. 4. Draft a list of issues tied to legal elements and evidence. Keep it current. 5. On disclosure requests, propose phased/issue-based disclosure with page/date limits. 6. If threatened with strikeout or deposit, propose narrowed alternatives and supply means evidence. 7. Draft witness statements to prove facts, cite exhibits, and avoid argument. 8. Request reasonable adjustments early, link them to functional need, and insist they be recorded in a CMO, benchbook support. 9. Maintain a comprehensive record, all correspondence, internal notes, logs, IT issues, service logs. 10. Always cite rules and precedents when making or resisting an application. Cross off any failures. That's where case fragility hides. You're not alone. Useful supports include support through court, process help for LIPS, law works, advice clinics and referral services, FRU, select representation in ET/SSCS, advocate, pro bono, barrister support, transparency task force, accountability and data advocacy, online, LIP forums and peer support groups, cautiously always verify advocacy. Now I'd be glad to take your questions. I'll provide general guidance, flag routes, risk nodes, and framing, not case-specific legal advice. If a query needs document context, I'll explain what I'd want to see. The slide includes a QR code linking to Legal Lens's resource pack, templates, checklists, and updates. Feel free to scan now for immediate access.
Fantastic. John, thank you so much. Thank you so much. And for those who weren't able to get to that QR code, if you want to put a link to where that QR took people, John, please feel free to put it in the chat.
Yeah.
John, you've given us a bit of an understanding as to what got you involved in all this. From what you said, it's basically about you fighting for your own case and
Yeah.
learning because you had to. When you, I'll kick off with a few questions, and we'll open it up to others before we then hear from Steve Conley, then Magella, then Paul Bates. As you've been going down this journey, what's been happening to your, if I can put it this way, John, what's been happening to your confidence levels? Are you feeling confident that a lay litigant has actually got a chance in the courts if they go about things in the right way? Or do you still think it's very much a David versus Goliath? Tell us about that.
Okay, so when I actually started down this route, I was quite naive, and I think a lot of people in this conversation will feel the same. As I started to learn a little bit more, I started to get kind of disheartened because I was expecting these different organizations and these different regulators to step up and basically do their job.
Yeah.
So there was a point, and I can't remember exactly when it was, when I started to learn more about the system, understand the system a little bit better, and that gave me more confidence. A lot of people, when they've not dealt with like the justice system or solicitors or barristers, sometimes they're a little bit nervous.
Yeah.
And being nervous with a solicitor or with a barrister, or even with like the system in general, you know, that can be used against you, and it can be a weakness as well. What I see most is that when people engage with the justice system or legal professionals, they try to make an emotional plea to them. And that usually doesn't work because you're dealing with a different breed of people. So that's when learning about law and the different processes that you can take will basically really help you out.
Good stuff. Thank you. There was a question in the chat from David Frood. What is a deposit order? Could you just explain that?
Right. So basically, when you go to court, solicitors and barristers, they have a playbook, and if you've got a strong case, and even if you don't have a strong case, they have a playbook that they all try to use against you. And one of those playbooks that they always tend to use is a cost order. And if they can't get, if they don't scare you off with a cost order, a deposit order is money that you have to basically put down to progress your case. Because the defendant solicitor will usually portray your case is it doesn't have merit or there's no reasonable chance of success. So
Yeah.
a deposit order is just to say, well, I'm confident in my case and I'm putting my money where my mouth is effectively.
Thank you very much. I touched on this hearing I went to on Friday last week, and the other side argued as best as they could that the good guy, I guess I'm oversimplifying, our chap, his they tried to argue that his case was hopeless and should be just struck out. They really did all they possibly could to completely demoralize him and make him lose the will to live. And I'm not being all that dramatic. And again, I'm so proud to see how he fought back on that. So, how much of this is actually a bit of a psychological battle of wills, John? I mean, it must take something to continue to fight on, despite the fact that it is David versus Goliath. They know more than you. They have more money than you. They know the routine and the ropes and the procedures, and who knows whether they've got any influence on any of the workings of the judicial system. How much of this just comes down to complete determination and will to win? I mean, what's it like emotionally going through these kind of cases?
It's horrendous. Like I deal with quite a lot of employment tribunals, and
Yeah,
what I say to people is that if you can settle without going to employment tribunal, do it, because you will never be the same person afterwards. It really does change you. And like you were saying, um, basically the defendant barrister will really go after you and it will be a character assassination on you. And it's so demoralizing to see. I also a lot of my clients are ex-police, and when you mention ex-police, you would think that they understand the law, but civil law and criminal law is two different stories.
right,
And I had a guy, I think it was a few months ago. He had quite a strong case, but he overloaded his bundle. I think it was 7 or 8 bundles. You're talking maybe 4 or 5 thousand pages. So even before we got into the proceedings, the judges had to adjourn for 2 days just to read through it. Because if you've got a judge, their job is to read through every single page. They've got to understand your case. They can't skip pages. I do think some of them skim pages, but that's a different story. But on that particular case, the barrister was extremely aggressive. And during cross-examination, my client, he just broke down and he just said, I can't do it anymore. And he just gave up. Um, and unfortunately, the majority of cases are like that because they're so aggressive the way that they come after you. So you've got to be prepared, you've got to be resilient. You've got to try and let things wash over you and not take it to heart too much. Um, because at the end of the day, they're just doing their job, even though it feels like it's personal. And it will be personal because it's your case. Um, but you've got to become really hardened if you intend to go into court and into litigation.
I, I understand. Thank you very much indeed, John. Thank you. Um, you're really opening my eyes up to the emotional journey as well as the kind of technical professional journey that people have to go through. Um, I've got a sales background, and very often in a sales background, if you're about to go and do a big pitch to a really big important client and you needed the business, then you'd often sort of role play it with somebody. You'd kind of role play the intended meeting with somebody, and they would deliberately, as a favor to you, give you a hard time, so that when the real thing happened, it felt not as bad as it would otherwise have felt. And sometimes that role play proved to be absolutely priceless because it brought issues to the surface that you might not have thought about. Um, what do you think about people like us lot, working with each other to, for want of a better phrase, role play the case or role play the argument to try to prepare people for what it's going to be like?
I think that's a great idea. I mean, with my clients, I will prepare questions for when they're on the stand, really aggressive
Yeah,
questions as well, just to
right.
prepare them for the emotional journey that they're going to go through. And what people need to also realize is that when you're dealing with like solicitors and barristers, they're not only legally trained, they're also masters in negotiation. They study psychology
Mm,
as well. So
yeah,
sometimes you will feel triggered, and that's because they've gaslit you. Or what they will do is you will have a valid argument, your point will have merit. They will anchor on something else, they will reframe it, and then they will future pace it. So the point that you had merit on is kind of lost in the whole story of it then. So doing some psychological education is also worthwhile. But yeah, coming back to role playing, I think that's a very good idea because nothing really prepares you and until you're in that room. But if you can do a couple of role plays before it and you know people that have been in that circumstance and that situation, then I do feel that you'll be more prepared going in.
thank you. I see that we have a question. We have. Forgive me, I'm not exactly sure how to pronounce your name, but we'll come to you in just a moment. But just before we do open up to others' comments and questions, once upon a time there was legal aid, and I think I don't know the rules. I don't know what they were, but people used to be able to get legal help if they didn't have the money to pay for it themselves. Um, I think it's a lot harder to get that now, isn't there? Isn't it? I, looking at this from a societal point of view, I really don't know how satisfied society can be knowing that so many people are having to try to win complex, difficult, challenging cases where the stakes are really high. Could be the home being repossessed, could be the life savings taken by a fraudster bank or whatever. I really don't know how satisfied society can be knowing that miscarriages of justice are probably happening on a routine basis. Not necessarily, I'm not saying because the court's corrupt or something, but just because one party just doesn't know how to argue their case, so they can't afford to get the legal support they needed. Thank you, John. This is so helpful. We're all very grateful to you for preparing that slide deck. Um, can we go to Xenia or Shenia? And please teach us how to pronounce your first name. And you're very welcome here. Thank you for being here. Please tell us how to pronounce your first name and then
Yeah.
share with us whatever you'd like to say. Thank you.
My name's Xenia.
Xenia, thank you very much. Over to you.
Xenia. I like the
Xenia.
Greek Xenia. First of all, thank you very much for putting on this meeting, and thank you very much, John, for your words so far. I'm going to try and make this general. I've been in an employment. I'm bringing a case as a person in litigant against a very large exam board, and it's now 5 years because of the backlog of the pandemic and because of their ridiculous failures to disclose information. Time and time again, they've missed deadlines, and then information has come out. Literally November last year, information came out which I'd asked for in August 2019. So my case dates back to events in 2019. Two of the key people at the organisation responsible for my situation have now left the organisation, and they are trying to say, their respondent is trying to say that in the interest of fairness, it's no longer possible to hear my case because two of the key people have gone. But so on December the 4th, they're doing an application, have my case struck out, despite the extensive documentary evidence which shows that I was subjected to detriment as a result of raising protected disclosures. And the Charity Commission upheld my complaint and Ofqual upheld my complaint. So my question is whether you're aware or you can signpost me to where I might find precedent about the length of time it takes to bring a fair case to hearing. Does that exist? Sorry, it's a bit long-winded.
Yeah, I understand what you're saying. Off the top of my head, my honest answer, I'm not sure. I will need to go and look at the legal databases. I have come across cases that, you know, with employment tribunals where they have gone on for over 10 years. So just thinking through that type of logic, I think you should be okay, but I can't say 100% for sure. I need to double check for you.
That would be very helpful. Thank you. And we'll circulate those. John, if there's any way of you doing that before about 10 o'clock tomorrow, that would be great because then we can include it in the follow-up notes that are going to be sent out. If you can, but don't worry if you can't. We can always send a follow-up note. What Senya spoke about is kind of similar to what Louise Stevenson put in the chat. Louise says, "Hi John, can you give some suggestions of sites to research legal precedent? I tried to register on a few sites, but it seemed like I was not eligible to do this because I was not a solicitor. Many thanks for your time tonight."
Yeah, this is a massive problem because this is where the playing field is not level, because solicitors and barristers, they have access to tools that the normal person doesn't have.
Right.
Off the top of my head, there is a free database. I think it's, I'm just gonna look for it now. Let me just have a quick look. But the problem is that these free legal databases, they're not the best to navigate,
Yeah,
and
so
the paid services are a lot better. The one that I would recommend
thanks,
would
Paul.
be Felix. That's very good, but it is expensive. I'm just looking for this. I mean, you can go to the National Archives, that will give you some information. But there's another service as well, which I'm just trying to find at the moment, which I can't.
We'll be hearing from Paul Bates later. Paul Bates is a thoroughly decent human being who does what he can to help TTF and our members. Paul's unusual because he's a barrister licensed in Canada and in the UK. And we'll be hearing from Paul later. And he just put a link in the chat to something called Bali. I don't
Yeah,
know.
that's what I was looking for.
Lovely. Thanks, Paul. Thank you for doing that. Thanks, John. Thank you again, Mr. Paul Bates over in Canada. Nick Rogers, you had your hand up a few minutes ago. We'll go to Nick and then we'll go to Michael Toppin. And I'll, for those of you that don't know how to put your hand up digitally, it's quite easy. Just look at the menu at the bottom of your Zoom screen and look at the React piece, and it will show you what to do. Mr. Nick Rogers, nice to hear from you, Nick. Good that you're here. Over to you, Nick.
Hello, Andy. I feel I've been through this quite recently, and I put an application in for a DSAR for like a freedom of information request for information that Lloyds Bank were withholding from me. I eventually received 3 tranches over the period of a year of information, which I knew they'd had because I had documented it all before I sent it to the bank. Anyway, I realized that they were withholding some very serious information, which I know they should have had and should have released. So I put a DSAR request in into the court. I went into the court and said, could I have a form to fill out to make a DSAR request? And they kindly gave me a form. I completed it to the best of my ability. I was going to be a litigant in person anyway. And when the first case came up in front of the judge, he took a line which I wasn't expecting, which was, I forget off the top of my head the questions he was asking. It was more or less, was I asking for information because I was going to sue Lloyds Bank? This wasn't my my point. I was asking for information which I knew they had. What I intended to do with it was a secondary matter. Anyway, to cut a long story short, the judge asked all these questions which were totally irrelevant, chucked my case out, and dismissed it. I then appealed, and another judge very quickly also declined or refused my appeal. So I then was in a bit of a quandary. I thought, well, there's only one way to do it. I'll have to find a lawyer who specializes in DSAR applications. I must have tried about 20 to 30 different lawyers, none of which, well, I found two which were available, but after realizing that it was against Lloyds Bank, they both turned it down. So I thought, well, this is no good. Fortunately, because I've been in journalism for a long while, I have friends who have been very litigant, if you like, experienced. And I spoke to one of them, and he came back and he said, well, have you tried ChatGPT 5? I said, no, not really. I haven't heard of it. Well, I had heard of it, but I never thought of it as being significant. So I ChatGPT 5, and it was astonishing. I put all the information that I had, all the details, all the letters, the correspondence, and all the rest of it, and they could not have been more helpful. I have to say, it's a very weird experience because you know, it's not like talking you and I. You're talking to someone who reacts so quickly and so competently and so in such a fairly friendly way that you're a bit sideboard. You know, you can't believe you're actually speaking to basically AI. Anyway, I have found it absolutely astonishing. They have managed to sort out all the case law, every document that I need to present, the way of presenting them. They even offer to write me the letters to send to the court. It has been a total game changer. And although many people may be a bit suspicious of AI, I have to say, in my experience, this ChatGPT has been astonishing. And from the experience of the information that I've received, I don't see how the legal profession can cope with something as powerful and as accurate and as honest as AI.
Nick, thank you very much.
I've got no extra. So that I'd just like to say, you know, please don't discount. It doesn't cost anything initially, but I pay, I think, about £17 a month. So because I feel it's worth it, and considering that lawyers would charge me £2,000-3,000, you know, not an hour, but you know, just to have a look at the case. And I've got no confidence anymore in lawyers. I've spent over £1 million in legal fees, and this is astonishing. So please give it a go.
Nick, thank you. Your comments are completely corroborated, if that's the right word, by many of our members who are very extensively harnessing the power of AI. And there's folks here who know a great deal about it, and you clearly already do. And point very well made. We're going to go. Thank you very much indeed, Nick. Thank you. Greatly here. We're going to go to Michael Toppin. I can see you, Michael. After Michael, we're going to go to David Escott, then to Stuart Cotton, and then we'll be going to Steve Connolly. And John Barwell, when we get to the end, I'll ask you for any final comments you want to make to kind of wash up on thoughts that come to mind as other folks are talking. Michael Toppin, can I please invite everybody to be as succinct as possible to give us a chance of making sure that everybody who wants to speak can. So Michael, the succinct version, please. Thank you very much. Thank you.
Thank you very much, Andy. I just wanted to make the general point that in the David versus Goliath world we now find ourselves in, AI and specifically ChatGPT is a huge game changer. So picking up on what Nick Rogers told us, which I totally agree with, I reverted back to a previous speaker who wanted to know where she could find precedents. You don't have to bother with all these subscription sites. Just go on ChatGPT. You can use it free, or you can do the Pro upgrade, which is a relatively modest subscription, as Nick has said, as opposed to getting expert legal advice. And it really does give you chapter and verse. I'm involved in a claim against NatWest Bank using FOS, who've been very unhelpful. I now have a lawyer representing me, and I have used ChatGPT to furnish my lawyer with loads of precedents and cases that he would have spent hours trying to find. And I've done the legwork, giving him the stuff, and he's done a fantastic presentation to FOS, and I'm very hopeful that it will bear fruit. So I would just say the experience of ChatGPT is great, and I do commend people to use that. But one word of warning, the judges don't like it when you say, oh, I found this on ChatGPT. Oh, did you? No, it shows the mindset. They don't like the Davids using great tools available to everybody. They want you to expend lots of money using barristers and lawyers. And just coming back to your legal aid point, Andy, the trouble is, as you know, the criteria have become so onerous, the threshold where you have to present the possibility of a successful case before you can get the legal aid. You have to have shown you're virtually destitute. And lastly, the trouble with legal aid is, by definition, because the people who work for legal aid don't get paid very much. If you pay monkeys peanuts, you know, that's what you get.
Thank you, Michael. Thank you very much indeed.
Well, people. Okay, thank you very much for hearing me out.
Michael, it's always a pleasure, sir. Lovely that you're part of our community. I'm really pleased that you are. We're going to get the succinct version from David Escott, then the succinct version from Stuart Cotton, then we're going to go to Mr. Steve Conley, who I'm sure is also going to mention AI. David, thank you.
Yeah, oh, thank you very much. John, where are you? You've gone. I've got a lot of overlap with you, a tremendous amount. I was going through your website. I've basically been litigating in person for the last 25 years. I started in Spain. I've been in Srinagar High Court in Kashmir, and I won my case. I had all the lawyers watching me. And I've got a massive corruption case. It's on the level with the Great Post Office scandal. It involves massive corruption. I've got forgery of an HSBC bank account. And I've been up against, the issues have been in the reverse. I've been up against incompetent barristers, representatives, and it's rather a famous case, actually. I've got here the bundle by De Vita Platt. They were intervened by the Solicitors Regulation Authority. I was reading the comments about the Solicitors Litigation Authority also on your website, but I'm fascinated actually because I've already posted on your website, you go into the Masons and their influence on the judiciary. And you had a comment by Bruce MacDonald talking about His Honour Judge Paul Matthews of Bristol High Court. The judgment of Bristol High Court on Bath versus Escott, and that's the precedent, which is a false precedent, which I've already posted, was by His Honour Judge Paul Matthews. Bristol High Court in 2017, when my case came up, my sister has been litigating for 25 years since our mother died. She was a Macaulay, actually. Lord Macaulay was my 3 times great uncle. And I was in Srinagar High Court, where the Macaulay Penal Code is still the Indian Penal Code.
David, I'm going to ask you to wrap up.
Okay. My question is, John, how far have you gone in from your website into the issue which your blog came up against His Honour Judge Paul Matthews, being a Freemason. As I say,
I have a suggestion. Sorry to cut across you, David, but I'm doing it for a very simple reason. I think it's wise for us not to talk about individuals in the way that we might if we let the conversation run. So what I'm going to do, Alexandra, please introduce David Escott to John Barwell by email, and then you two guys can have a separate conversation about that particular matter. Thank you very much, David. Thank you very much, John. Let's go to Mr. Stuart Cotton. Stuart, thank you.
Thank you very much, Andy. Hello, everyone. I have a long background of litigating in person, defending lots of limited partnerships in toxic film schemes. I've had to go to tribunals at High Court for the blocking of trying to dissolve companies. I've had to go to the High Court to explain how frauds work and how these are victims of various frauds. I've also been involved in probably the longest running eviction case in the whole of the UK. I lost everything as a whistleblower. I've had 3 distinctly dodgy landlords since. I've taken the last lot to court, and I've avoided being removed from a property on 4 different occasions by successfully going through the process and beating them in the courts. What I wanted to say was about AI. I'm a bit of an expert on AI. I'm building a data center in Scotland at the moment. AI extrapolates information. So if you ask the question in the wrong way, it will give you the answer that you want or the one that it thinks you're looking for. So you always have to check that it hasn't invented something in the hopes of appeasing you, as opposed to giving you a direct reference to something that's useful to your case. It's always worth asking it several questions. After you found something that you think you want, it's always worth asking it very specific questions like, is this precedent case real or have you made it up? And then it will say, oh yeah, sorry, you caught me. I extrapolated it from 3 other cases. It does that a lot, so I check in with that one. You can get involved in fights between AI and AI, so ChatGPT and Copilot. If you're dealing with a solicitor who's also using AI to make their job easier, you can end up in a whole spiral whereby all you're doing is arguing 5 minutes apart between different AI bots, and that doesn't get you anywhere. You have to somehow stop that process. The thing that I think it's best useful for is finding out the procedures. So I think where most litigants in person fail is in not understanding the language of the court, the processes of the court, the procedural rules, the evidence that you've got to do, how your bundle's meant to be formed. ChatGPT is excellent at setting out how you need to do things. It's excellent in setting out a witness statement and so on. So there are incredible things that it can do. There are also things that can really set you back if you don't know how to give it the correct prompt. That's basically my point.
Stuart, like Michael Toppin, you're a pretty new member to the TTF community, but you're making such a very valuable contribution already, Stuart. I'm very grateful to you. We'll all be hearing more from Stuart and Michael and others in due course. Steve Connolly, thank you very much indeed. Whilst Steve's kind of about to take the mic, I'll just say that Steve is one of many people in the TTF community doing a huge amount of work on a purely voluntary basis to try to make the world a better place. And I'm forever grateful to the work that Steve and other volunteers provides to this community. Steve Connolly, over to you. Thank you, Steve.
Thank you, Andy. And I think I will mention AI a little bit in the presentation. So I just wanted to talk just for 5 minutes and give sort of 5 minutes for questions and answers. But basically, in response to seeing the harm that financial exploitation delivers to people, to individuals, I've sort of made it my mission to try and help individuals. Initially, it was to help victims of financial exploitation rebuild their lives and get back, because obviously many, as Andy had referred to, are in a very kind of low place, having lost everything, it's important that they have a perception of a future that's optimistic in order to get people back up again. So the initial program I ran for the Transparency Task Force was called Rebuild and Thrive, which is a program, AI supported program, to help people create a life plan to get out of the rut that they were in. But also then what I discovered is that more important than getting out of the life rut was getting justice. So I basically took my techniques, the AI tools that I used, and applied it to this particular problem. And as a result of that, I've set up a project called Get Safe, which is get support after financial exploitation. I think I can post the link to the page on the link there, so you could be having a look at that. So I'll just tell you a little bit about Get Safe. Get Safe then is using AI, using life planning, using the ability of ChatGPT-5 to analyze cases and produce great case files, great guidance. And yes, there's got to be mistakes, and you have to have a process that double checks for that. But I tell you, it's 1,000 times better than I could do, or any of us could do. So trying to do it without AI is like almost impossible, and it really is a David versus Goliath battle. So I'd encourage you, don't be discouraged that it might give you hallucinations from time to time. It's going to be 1,000 or 10,000 times better than anything else you could possibly do without it. The idea is not to replace legal representation, but to do all of the work that needs to be done before you get a case where there's legal representation required, to get that bundle together, to get all the correspondence that you need to have with all the various parties, with the bank, with the investment advisor, with the ombudsman, with the Financial Conduct Authority, with your MP, all these items of correspondence with the any complaint services that you need to support in delivering something, and it's going to be 1,000 times better if you use ChatGPT, the free version, or the $20 a month version. I use the $20 a month version. I have on the call here, there's several people who joined me on Get Safe. So we have a few Get Safe representatives dotted around on the call. So you might want to ask them what their experience of it is. Today I launched something, and I put it on the website, and it's called the Financial Exploitation Checker. And rather than using ChatGPT, if you don't want to use just the raw site, there's actually on the site link that I've given is a financial exploitation checker where you can actually just load your case, and it'll tell you what the red flags are and tell you the case law precedents, and it'll even then write a letter for you of complaint. So that's all instantly, and it'll just happen instantly. Just have a look at that. It's free. So just have a look at that. So that's the financial exploitation checker. We talked about bundles. So what I've also done is, and there's a link on the page that given to something called the Citizen Investigator Playbook. And it's basically a bundle. It's on a template called Notion. And it basically sets out how you can create a bundle. And it gives you instructions on how to do that. And you can ask ChatGPT, can you produce a file note for this piece of evidence that I can upload onto my Notion file? So you ask for a Notion template and upload that with your piece of evidence. It goes and you start creating this bundle. In addition to that, what there's also a link to is something we've called the Goliathon. So this is a play on David versus Goliath. And what we've done is we want to level the playing field. We don't want information asymmetry in this financial services industry where you've got banks who've got lots of everything and we've got lots of nothing. So what we've done is we kind of get our mechanical suits on, which is ChatGPT-5, so we can have our guns trailing on the bank or on FOS or wherever, and we use the ChatGPT-5 mechanisms and the Notion template and everything to absolutely blow the case out of the water. And I just pick up on what what's been said. Nick, you said it was outstanding. It is outstanding. The result is absolutely mind-blowing. Michael, you said it's a game changer. It is actually a game changer. It's massively improvement on anything you could possibly do. And yes, if there are risks, but you're a citizen. You're not supposed to be a legal expert. You're a citizen, and not very well equipped citizen. And this AI will equip you so that you can fight. You'll actually be running rings around them. You'll be running rings around the bank representative. And I've been doing it on a few cases and running rings around people who didn't expect it. And so is the members of Get Safe. So do have a look at Get Safe, the site. Have a look at the financial exploitation checker. Try it. I just tried it. I don't know if I can share on screen, but I just tried it on a question you asked during. I'll just share the screen so we can have a look at that. So that's a citizen investigator playbook, and it's a Notion template. Let's have a look here. So I think I used electronic bundle rules. Yeah. So basically, I asked the financial exploitation checker, and I just copied in a comment from the chat. Hi, I'm being sued in county court under the small claims procedures. I'm told that I can't serve an electronic bundle. Can this be true? And this is what it gave me in 10 seconds. The answer is no. It's not automatic. And then it says what the rules say. Here's what the civil procedure rules say. Communications, bundles, e-bundles, small claims tracks. So it gives you all the information. Why someone might say yes, say you can't serve electronic bundle, and it gives you all the kind of reasons why that. What you should do and check in your case to see if it's relevant. If you would like, I can look up specific court, e.g. Leeds County Court, your local court, practices on any recent. And then it gave me a note. I asked it to summarize the answer, and I posted that into chat about 10 seconds later. So that's the sort of thing it could do, but you put your whole case in there and it'll write the letters for you. So, if you want it. So this is what the financial exploitation checker does. It just tackles all your legal stuff. But yeah, you need to check out that some of these things, if you're going to go to the court and quote something, you need to double check that that's real. And people are giving you some clues on there. So that's all I'm going to say, because it's like I wanted to keep it short. But there's lots of stuff available on that link that I've shared. And there are people on the call who I've worked with who can perhaps talk about their experience if you want to hear that.
Steve, thank you so much. As always, you bring so much so freely, and it's so bloody helpful. Oh, excuse my language. It really is. Steve, thank you very much indeed. I'm keen that we end at more or less the right time. So we're going to hear from Magella for maybe 5 minutes or so, then from Paul Bates for 5 minutes or so. Then we'll have a bit of a wash up. I think we're probably going to finish at about 20 to 8 UK time. Thank you very much, Steve. Thank you very much indeed. Magella, please take a moment very briefly to introduce yourself first of all, and then share what you'd like to with the group. Thank you.
Okay, well, my name is Magella Rippington and I'm a lay litigant. I've been a lay litigant since 2011, and you're constantly in a learning process with the lay litigancy. You're actually serving a pupillage in your own proceedings on the hoof, and it's very difficult, and you're not going anywhere until you get some help, and a lot of it is going to be self-help. I appreciate what everybody has said this evening, but I want to give you some tools and I want to give you some tips for the courts. The information I give you comes from my experience with the courts, my experience with lawyers, from professors, and from judges in particular. So first of all, you need to get a start at the base, and people do need some help. So first of all, if you have a pen and paper, there are some things you're going to need to take down, and if not, I'll get them on a note to you. One of the first things you need to do is you really do need to get some kind of a little help with a course or something. And as it happens, there is one coming up in November. I'll tell you about in a moment. You're in an adversarial process. You're in a civil system, and to be a lawyer is a great privilege. To practice law is a great privilege. And the profession was in time, medicine, law and theology were the three professions, and they were for the betterment of the public, not for commercial gain, but more so and that's where the professionalism came in. Now, there's a very good article called A Lawyer's Duty to the Court, which will explain all of that. To get to the start, there's a great set of videos in the UK run by the BBC, and the narrator is a King's Counsel. His name is Harry Potter, and it's a strange case of law. You have to watch those videos. They're easy to follow. They will help you get a grounding in the common law, because we took our law from the UK. We were the first adventurers of the common law. And if you don't understand that, you're in trouble. So that's one of the first things you need to get. Also, to help lay litigants, the Master of the Rolls in Northern Ireland, Evan Bell, wrote a very good article called Judges' Decisions, and it will help enormously. It'll tell you, it lays out the typical litigant, and then it tells you what you need to do. Now, I got great advice from a senior counsel who was helping me along the way, because I'd already done my kind of paralegal studies. And if you do some kind of paralegal studies, or even take a secretarial course for a lawyer, to work in a lawyer's office, those courses are immensely helpful. So what he's told me to do: go in with your argument, give your key argument to the judge, sit down and shut up, and let the court do its job. Do not go in to be a pseudo solicitor. The first thing I would say to people as well, I'm just going to throw these things out at you because it's just that the time is short. The first piece of information, and maybe that would be a piece of advice, is try and mitigate, not litigate. Litigation has about 7 to 10 steps in it, and it can span anything from a year to 15 years. Usually 7 to 15 years is the length of time for litigation. And at the end of the day, there are no winners in litigation. Even top lawyers going in have great difficulty trying to win their cases. The magic in putting a case to the court is having precedent. There's no point in, you don't go to the court for justice. That's only a concept. You go to the court for the law. And when you go there, you must fight for the law with the law. And going into court, you need to know what the issue is before the court. What is the judge asked to decide? He's like the umpire in a tennis match. He's going to sit there, or she's going to sit there, and you have to bat and win the points and win the game and win the match. They can't give it to you. And many times litigants are going into court and they feel they're being had or they're being disadvantaged. Their papers aren't right. It's not so much the volume or how you put the bundles together. It's all about the content, having the winning argument. And it's better to have one key piece of precedent that puts your case to bed than having a booklet with 50 or 60 precedents in it and authorities. And I've had that experience where I've gone in with the one piece and my opponents withdrew before we even got into the court. One of the things to remember, just throw these things out as quickly as I can. When you're going into the court, you have to stop before you go in and leave all your baggage outside. No emotions, no nothing. You're going straight into the court to deal with an issue. And you must remember two things. A, the clock is always ticking, as in time for limitations and that. And the second thing is the cost is running, the meter is running. Costs, every time you step across the threshold of the court, there is an element of costs, even when you take motions. Now, court cases, sometimes when proceedings are issued, it's never really intended that the proceedings will go the full journey. They're always going to be dealt with and cut short by interlocutory motions along the way. Courts like to see people trying to settle, and don't be afraid to go into the court and tell the judge that you want to have your matter settled. It's your preference. Litigation is costly, and the more you seem keen to litigate and the more vexatious you become, the courts don't like it. A litigant becomes vexatious when they don't have the money to fund litigation. We are in a civil legal system. It's private. We're well past the day of petty sessions. Back in yesteryear, when the courts were all about the petty sessions of yesteryear. Today, we have people need a lawyer as much as they need a doctor or a dentist, but unfortunately, there is no system there to facilitate them. So when they're going to court, what is a court? A court is a mere bundle of rules. So you can't really be in the court unless you fully understand all of the superior court rules. That's a massive book. You need to understand all of that. You need to understand the common law system. You need to understand the civil system. And you also need to know how to do legal research, because you might rely on a statute and you go into court and you find, well, that statute was amended. And then even if it was amended, you then have to find out, well, was there perfected? So you really have to, and AI isn't going to give you that. You have to know how to do precedent and how to find research. And although we've spoken tonight about the site Bally, and there is an Ireland, that's the UK site, and there's a similar site here in Ireland, there is another site. You can go into Stardesis. It's not as expensive. I've paid for a short period of time, but a group of people could get together and have their own number to get in, their own PIN to get in and take out an account with Stardesis. And if you listen carefully to, there's a very good podcast called The Fifth Court. It's run by lawyers and they run the Stardesis as well. And you should be listening to that. You have to, if you're going to go into litigation and you're going to defend yourself, you're going to have to find the time to read and to study. So I would recommend to everybody, start with the strange case of law. There's a professor on as well that you might consider looking at. His name is Professor Waldron. He is an exceptionally good professor. He's a philosopher and his name is Jeremy Waldron, and he's a lawyer, and he does some very good talks and some very good videos. The UK, unlike Ireland, provide a much better platform for learning about the law and for self-help and for courses. So that's important. Anybody who has the time, try and speak to the Law Society this week. There's a course coming up in November. They have a civil litigation course in there, and it covers all of the modules that you will need to be before the courts. There's no point in being down in the courts if you don't understand it. You have to understand it and you have to get help. And other lay litigants can't go in and help you. Even though there is a Mackenzie Friends situation, it's still not ideal. The other thing is to remember, always check thoroughly with the court services. Follow their templates. When you're putting books into the courts, follow the directions. People think they're going for mention or they're going for directions, they don't have to pay too much attention. You must pay absolute attention to directions, to case management, and it might be no harm if there was better time to give a talk through from the time your proceedings are issued to you and the steps that you have to take and why you have to take those steps and maybe to avoid the pitfalls. But the one and only person that is most important in the court is the judge. He or she is the person who are going to decide who to give the order to, who's going to walk out of the court with the order, and who is walking out with the costs. Because in our system here, costs follow the event. In other words, it's really the loser is going to pick up the bill. Now, there are exceptional circumstances that can come into play that might change that for some people, but the law is, the rules are, Order 99 has a whole list of sections in it. You need to read that and understand it, because when you're going to call on a motion, you need to know, are those reliefs permissible? And how do I draft the papers to get those reliefs? How do I put in a grounding affidavit to support that request? And how do I write my papers in such a way that the judge is going to take note and that I will have a fighting support? And so,
Majella, thank you. You're covering such a lot of ground. It's extremely useful. And listening to Majella and others, I'm definitely of the view that this is going to be an ongoing topic that we'll be revisiting to try to build up our knowledge in this space.
Yeah.
Majella, any final point from yourself before we go to Paul Bates? Thank you, Majella.
Thing I want to add to before I go, and this is very important because there are people going into court this week, next week, and every day this week. Bring in your sheet of paper with you, your notes, and write at the top of it, shut up so you don't say too much. Underneath that, and write it in big writing, stay the order pending appeal. This is vital for people in court this week. You may not be going to appeal, but even if you are not going to appeal, ask for it, because if you don't, you're then going to have to take a motion to get an extension of time. You want to avoid that. So if you need an extension of time, you're now going to have to meet a test before the court. You're going to have to understand Air Continental versus Clonmel Foods. And that whole process is just overburdening you, when all you had to do at the beginning was say, Judge, would you stay the order pending appeal? Now, only if the order goes against you. You don't ask if you're after getting the order, but it's vitally important that that's on the tip of your lips going into the court every time you're in court. The second thing is, people go in this country, go into appeal, and they have never even heard of the Hay and O'Grady, which is the leading case where the principles of the Hay and O'Grady have to be met to go into the appeal court, which is a review court. These are areas that litigants are getting tripped up in every day of the week. It's important because, you know, you shouldn't even be in the litigation. You are in the litigation, and these are the areas where we're falling foul. And then you're walking out of the court thinking, well, the judge is really bad to me today, or he's a crooked judge, or she's a crooked judge. And when in fact you aren't properly prepared before the court, and the judge can't help you. So there's a lot.
Majella, thank you.
Covered. Yeah, I'm sorry that
Majella, thank you.
Just
all right. Please don't apologise. Everything you said has been very, very helpful. And as I said just now, we just need to revisit this topic on a regular basis to share all the knowledge and insights we've got. Majella, thank you very, very, very much. Mr. Paul Bates, over in Canada, please do reflect on what's been said, but spend a minute or two, however long you want, really, to succinctly cover any thoughts that are front of mind for you, having heard what's been discussed tonight. Thank you, Paul. Thank you.
Well, I salute the speakers in today's program. There's a lot of intelligence and experience being reflected here of how to proceed and what it will be like to do so. I would say that in many areas of law, and my experience is primarily Canadian, there are litigants in person. In criminal and family, the rate in Canada is up to around 30% of people appearing in person. I would be surprised if it's much different in the UK. And that's a very significant trend and increasing markedly. Also, and that's in the courts. In the tribunals, it's even higher. And that's because there's a sense that people can muster the skill to run the procedures in a landlord-tenant dispute or whatever. So the reason for that trend is that, in my view, lawyers have failed. The system's been made so complex that it's expensive and slow. And so people resort to appearing in person out of necessity. And so I think this trend is going to continue, I'm sure, in the UK and in Canada. So it's a reality that's very much here to stay. Judges are getting training now on how to deal with litigants in person, because the judge ultimately continues to be responsible that the procedure be fair and conducted according to law. So that means the judge is not supposed to assist one side or the other as an advocate would, but he has to, or she has to, make sure the case gets presented somehow to them. So I think you're studying a very interesting topic. What I would say that my most impressive view was of the speaker who said that it's important to get the procedures right using, for example, AI tools like ChatGPT. You have to be in the right courthouse, in the right place, with the right forms filed. And, you know, I think you'd have a hard time doing a competition appeal tribunal brief. Those are tough. But for a simple breach of contract or dispute with a lender, that's not necessarily so tough. So make sure you have the right courthouse, the right procedures filed, the right forms filed, and go in the right place, and then get going. Ultimately, what gives an advantage to litigants in person is the court's conscience. The court wants litigants in person to be treated fairly and heard. That they may make a very good point without resorting to a stack of legal authorities. I can tell you from hundreds of experiences in Canada, judges loathe the 7-volume brief of authorities and love the 1-case or 2-case presentation, which good lawyers do, but so can litigants in person do it. So I think I wish you the very best. I would suggest, if you have some doubt, get a lawyer under a limited scope retainer to give an overview or a suggestion or an hour of advice on how to run the case, what to put in forms and whatever. It's probably worth that. In Canada, I like doing that for people, just as a matter of fun, actually. So I think that's my best suggestion to you. I wouldn't be intimidated appearing in person if I were you. I wouldn't be intimidated by the court. Speak honestly and clearly, just as you've done today. The court will listen, and the court must be fair. I've been at many tribunals in the UK, including the Employment Tribunal, and as far as I can see, they're just as receptive to litigants in person as young lawyers as speaking to them. So well done, Andy. This is a great program. It's interesting to hear people's views.
Well, thank you very much indeed for your input. As always, folks. It's just thank you, Paul, very much. It's just 7:30. We're going to go back to John for his final comments before we wrap the session up. But before I do, does anybody else have anything they are itching to say or ask before we close the session? Please do raise your hand so I can see you. If not, we'll go back to John Barwell. I think that's good. Let's go back to John. John, any final comments, any reflections on what others have said? What else would you like to say, sir? Thank you, John.
Very useful session today. A lot of good input from everyone. And the two things that I would just like to say is AI is a great tool, but don't be over reliant on it. It does hallucinate, and I've personally had it when I've used AI and I've gone into a tribunal and it's hallucinated case law, and I got absolutely blasted by the judge. So
Right.
Use it as a tool, don't use it as a replacement. The second thing that I would like to say as well, and we've not really spoke about this, but subject access requests, they're not a legal tool for discovery. A lot of people get frustrated that when they use a subject access request to get disclosure, they know the company's hiding information and they can't get access to it, but that's not the right way to go about getting disclosure. So I see quite a lot of litigants in person who are quite reliant on subject access requests. Just remember, it's not the legal tool for discovery, and there's a process to that. Apart from that, great session today.
John, thank you very much indeed. I'm just put a note in the chat here. Huge thanks to all our speakers tonight. John, Steve, Magella, and Paul. No one's been paid for their input tonight. It's all been voluntary. Can we please show our appreciation to all the speakers for their contribution tonight? And we will be running this session again, and we'll think about how to optimize it. Once upon a time, Abraham Lincoln is reputed to have said, "He who represents himself has a fool for a client." Abraham Lincoln, he who represents himself has a fool for a client. I wonder if the practice of harnessing the power of AI as a tool and the practice of sharing knowledge and experience with each other may make that statement, that quote, obsolete in the future. Thank you all very much indeed. Thank you for being here. Have a good evening. Thank you very much. Good night all. Good night.